Real estate transactions and contracts are at issue in this video. So we're going to be concerned about real estate deals involving contracts and deeds. This is important material, and it's important to realize that a lot of this stuff owes more to the law of contracts than it does to the law of real property. So we need to have in our minds a framework for analyzing contracts issues. It's important to understand that in the law of contracts, we have to analyze a fairly complicated set of issues. First, we consider the formation of an agreement, offer, acceptance, and consideration, and we concern ourselves with whether or not the defendant might have a valid defense to formation. If there's no contract, the plaintiff loses. Next, we consider the breach of the agreement. Here again, we have to carefully examine the facts and consider whether or not the defendant might have a strong defense to the breach. Then finally, the plaintiff is going to have a prayer for relief. That set of remedies can include damages, restitution, or equitable relief. And when we're dealing with real estate, we know that specific performance is the most preferred remedy. And also to the extent that a plaintiff in a case involving real property has a tort theory, we've got, again, a preference for equitable remedies. So one of the things that makes the law of real property a little intimidating is the fact that all of the various possible remedies arising out of torts or contracts potentially can come into play here in the law of real property. So with regard to real estate contracts, the first thing we've got to do is acknowledge that we're dealing with the law of contracts first, and then real property is sort of the secondary motif that we have to be prepared to analyze. So the relationships that we're concerned about here are contracts to buy and sell land and conveyances that are made with deeds. We can see that these contracts are fairly easy to create, but they have to comply with the statute of frauds. Because we're dealing with interests in land, we've got to have a writing. And in order to be a satisfactory writing, we've got to identify the parties, the subject matter, and the price. And the parties have to exchange promises. Here it's typically a promise to pay or a promise to make a series of installment payments in return for possession of the property and a deed signifying ownership. Now, we don't need to identify the land perfectly. All we need to do is reasonably identify the land. So if we've got a purchase and sale agreement in which the seller says, I hereby convey all of the real property that I own in our city, that is probably a satisfactory identification. Similarly, if the plaintiff and the defendant make some reasonable effort to identify the property, but their contract doesn't really do a satisfactory job, this is a situation in which the remedy of reformation will apply. We will help these people create an agreement that we can enforce in court by reforming it to reflect the true intent of the parties. Now, that is not to say that we can be so sloppy as to fail to identify the property really at all. There has to be an adequate description of the property, but it can still be reasonably loose. Also, it's possible to imply a reasonable time for performance. Still, we've got to identify the parties, the subject matter, and the price. Also, different real estate contracts have a different degree of warranties being made by the seller. There is a general warranty deed, there is a special warranty deed, which is somewhat more narrow, and then there is a quitclaim deed, which is essentially a deed without warranties, in which the seller is conveying whatever interest they may actually have in the property. We also see that typically there are warranties of marketable title, warranty of the right to convey, etc. And we can see also, as we analyze the interests in land, the need to go back across the chain of title. This is a set of issues that's much easier to learn through studying hypotheticals than it is learning just in a vacuum. But it's worth our time right now to say that we have to be able to engage in a chain of title study, and to the extent that a title has been recorded outside of our chain of title, we'll be excused for our failure to find it. Also, we realize that zoning laws can impact a real estate transaction to the extent that the parties are not both clearly aware of what the zoning laws are. Again, it's likely that you will see this issue arise in a hypothetical, but it is not a central issue. One fairly technical issue that is central enough for me to refer to it in this series of videos is equitable conversion. This is an issue about who bears the risk of loss during the escrow period. And there are, as you might well predict, two basic ways of looking at it. One indicating that the buyer has an interest of land upon signing the agreement and that the buyer bears the risk of loss. And the other way of looking at it is that the seller bears the risk of loss until the end of escrow. Now, in practical terms, what this really means is which party has to take out insurance, because the risk of loss during the escrow period is a risk that is readily insurable. So equitable conversion arises and becomes a meaningful issue under circumstances where the parties have failed to insure the risk of loss and the loss has occurred. Then we just have to look to see which jurisdiction we're in and apply the law accordingly. So if you are responsible for local real estate law on an essay section of a state bar, probably it's in your interest to know which type of jurisdiction yours is with regard to equitable conversion. So we turn our attention briefly to consider the issues relating to deeds. If we are going to have a conveyance by deed, we've basically got to have three things. We've got to have a valid deed. That deed has got to be delivered to the buyer, and there has to be valid title underlying the deed. So the deed analysis requires deed, delivery, and title. Notice, and please realize, that we're dealing with two clusters of issues here in real estate contracts. We're dealing with the actual contract itself, and we're dealing with the deed. In the next video, we'll concern ourselves with the financing and become involved in mortgages. But for our purposes now, we've just finished talking very briefly about real estate contracts. Now we are focusing in on a sub-issue, the deeds that often are the subject matter of a real estate contract. We see that there are not terribly many issues with regard to the form and content of the deed. Certainly the deed has to describe the property with a reasonable degree of specificity, and typically that level of specificity is a lot higher than it has to be in a contract. Next, we've got to handle issues with regard to delivery and acceptance. We must acknowledge that the physical transfer of a deed gives rise to a presumption of a valid delivery. Now, there may be facts present that will help to rebut that presumption, but you need to know that when an actual physical document, a deed, changes hands, there's a presumption of a valid delivery. But in more subtle issues, what we have to look to is whether or not the person handing over that deed did so with the intent to make a present transfer of possession. Now, the classic situation where this occurs is where the grantor or the seller conveys the deed to a third party, an escrow agent. Is that satisfactory to constitute a valid delivery? Answer yes, although we would acknowledge that it's a conditional delivery, conditional on the buyer coming up with the purchase price. That's what we've got escrow agents for. Both sides make conditional deliveries, the deliveries contingent on the other party's performance. When both parties have performed, the escrow holder conveys the interests to the respective parties, the purchase price and the deed, and the transaction is complete. Realize that in many deed questions, on essays in particular, but also potentially on the multi-state, we've got to handle the covenants that are made by the seller of real estate. And there are three principal covenants that can be breached at the moment of the transaction. That is the covenant of season, the covenant of marketable title, and the covenant that the seller has the right to convey. It's probably in your interest to memorize that three-part laundry list, along with the other large stack of laundry lists that you have to memorize. But the reason for memorizing them is this. You may be called on to recite them and to discuss each of them briefly in an essay question involving a real estate transfer by deed where there turns out to be some problem with the underlying title to the property. Also, we know that a quitclaim deed doesn't have any covenants. That's the difference. Now, all of these covenants I've just mentioned, the covenant of season, the covenant of marketable title, the covenant of the right to convey, these are all covenants that are made by the seller that can be breached right at the moment of the transaction. But notice that the seller is also making a covenant of quiet enjoyment. That's part of a real estate sales agreement too, not merely a part of the lease. And the covenant of quiet enjoyment doesn't end up getting violated until the grantee or until the buyer is somehow ousted from the property. Next, we consider that with regard to these conveyancing by deed issues, we've got Recording Act situations. The recording of a deed is not required for the effective transfer of title, but it is typically required to give notice among the various parties. And we see that there are different types of recording statutes. There's a notice statute, a race notice statute, and a race statute. Each of these function a little differently. Their function is very similar to what their titles imply. Here again, I think it's much more in your interest to go forth, engage in a lot of practice, and you'll sharpen your knowledge on these various types of Recording Act issues quickly. You don't need to study it very much in a vacuum. Go look and see how it is tested. And that leaves us with just a couple of other little wrap-up type of details with regard to real estate contracts and deeds. Sometimes you can be presented with a situation where a party forges a deed. A forged deed is a nullity and it has no legal effect. One technical issue that does arise fairly frequently is the issue of estoppel by deed. And the facts are classic, and they're tested the same way over and over again. Here we've got a grantor that sells Blackacre to a grantee, but this grantor has no title. Basically, the grantor is selling property he doesn't own. But the facts continue always the same way. At some time after what I think we'd agree is a fraudulent non-transfer, the grantor gets title to the property after all. Now, depending on what jurisdiction we're in estoppel by deed, the instant that the illegal grantor gets title, he becomes a constructive trustee, and all he has the right to do is convey title to the person that he conveyed title to before. It can get a little trickier than that. Study it in your local materials and see how the material is tested. But estoppel by deed sounds more technical than it is. We wouldn't have to have any legal education at all to have a sense about what's going on here. A seller and a buyer. The seller doesn't have the right to sell, but the buyer still pays for it. Later on, the seller gets title to the property that he defrauded the plaintiff over before. I don't think you need a high school education to have a sense that it wouldn't be fair to allow the seller to get title finally and then sell it again. We don't let people cheat one another typically, but the technical phrase that we use in this specific situation is estoppel by deed. And we can see that there are also situations where a transferee may choose to refuse title to the property. And here, typically, this transferee who wishes to refuse title will have to not just send the title that was conveyed by the seller back, but will have to convey a new title, quitting any possible ownership to the property. And that concludes the second part of our three-part analysis of real estate transactions. In our final video, we will deal with issues relating to mortgages.